Hello, I'm Detective Bradshaw with the City of Milton Police Department. The response to investigation and prosecution of a family violence complaint becomes a matter of official record when the investigating officer drafts the incident report. From that initial document, decisions are made regarding the disposition of the case all the way through the criminal justice process. Decisions about manpower, resource allocation, prosecutorial decisions on how to move the case through the system, and sentencing by the courts all rely on an accurate and complete report of the family violence incident. There are certain aspects of a family violence report that are unique to reporting practices than with other incidents of violence and property damage. There are specific mandates that must be performed and information on appropriate services and remedies provided to the victim to comply with the Family Violence Act. The Family Violence Report becomes the primary instrument that triggers a whole range of enforcement policies, protocol reviews, community-based support, and judicial interdiction. First and foremost, the response to a family violence complaint is to secure the safety of all parties involved and render aid to the injured. Once the scene is safe, the responsibility of the responding officer shifts to an investigative role to determine if a crime has been committed. The investigation usually begins by asking the parties what has happened and who is involved. From the interview, officers begin to orient themselves to the nature of specific criminal acts that may have occurred. This process leads to supporting evidence, both testimonial and physical, that would support a conclusion that there is a probability that a crime has occurred. Evidence can be circumstantial or direct and would either incriminate a person's involvement in a criminal act or disprove the alleged complaint. For example, the statement by a victim of assault that a particular weapon in possession of the aggressor is corroborated by the presence of the weapon and the proximity of the weapon to the accused would tend to incriminate the person. Evidence can be accumulated from the totality of circumstances surrounding the incident. It is important to realize that probable cause can be established from a wide variety of sources. Documentation of prior incidents, the officer's observation based on experience and training, as well as the physical evidence at the scene all contribute to the foundation of a criminal prosecution. The officer's goal is to document all relevant facts to be accurately disseminated to interested parties. Investigating officers should appreciate the relationship between the role of law enforcement and the courts to address the issue of family violence. Whereas law enforcement has very limited authority to order criminal or civil remedies in family violence incidences, the courts can impose corrective remedies only if arrests are made when probable cause exists. The key point is to have the officers take the information from the statements at the scene, then to connect those statements with their own observations and physical evidence to develop probable cause. Specific legislation has been imposed related to the documentation of family violence complaints. OCGA 17420 mandates that all domestic violence calls be documented under a heading, Family Violence Report. The incident type may be classified in accordance with local coding. It may be titled informational in nature when no action was taken, or titled by the criminal charge, but in all cases when officers respond to a family violence complaint, a report shall be filed. Specifically, when no arrest has been made, the report should document suspicions that justified the complaint and the reason why no action was taken. If no arrest was made, an explanation should be written in the narrative and may come under one of the headings, juvenile, primary aggressor, left scene, insufficient probable cause, or other reasons. To be in compliance with the legislative mandate, all family violence reports must have certain prescribed fields of information. The information is collected by GCIC and tabulated for statistical purposes. The information from these cumulative totals is then used by various service agencies for programming and training objectives defined and legislative action to modify relevant statutes. Because the data is tabulated in separate reporting fields, each department can record the incident on the state standard form or can reformat the report on a form that conforms to their own system. It is the accumulation of these statistics from throughout the state that creates an accurate profile of the issues related to domestic violence and becomes the basis of every form of civil and criminal remedy. As officers begin to investigate a complaint of family violence and write the subsequent incident report, they should consider who will be using the report information and for what purposes. The scope of any investigation, but particularly in a domestic violence case, goes far beyond just the investigation of a criminal violation. Procedures are reviewed and protocols adopted within the agencies to respond safely, investigate thoroughly, and prosecute effectively. For example, supervisors may review the report for the purposes of editing, compliance with department procedures, or determination of further investigation. Investigators that follow up on the initial response rely on the documentation of contact information, locating witnesses and understanding the significance of physical evidence pending analysis. Prosecutors may review the report to assure that elements of each crime have been adequately documented and to troubleshoot the report for potential constitutional challenges. Other agencies and personnel may have an interest in the report as well. When the responding officer has a full appreciation for all the related agencies that use the incident report, they will then begin to investigate all aspects of a domestic violence complaint. The concept of investigating from the perspective of the people who will use the report is frequently referred to as writing with the reader in mind. In addition to the normal types of evidence in a criminal case, family violence evidence can be supported by probable cause generated from facts particular to this type of investigation. Many of these elements have been established through judicial review and case law or have been documented in the historical record that may establish motive and intent. Prior difficulties. Any instance of prior violence between the parties in the current relationship, officers should seek any form of documentation, witnesses, medical reports, protective orders, or even uncorroborated testimony from the victim may be used. Similar transactions. These may be incidents of violence between the primary aggressor and any previous relationship. Although evidence of these incidents cannot be used as probable cause in the pending investigation, they may be useful to inform the prosecutor who may file a motion to enter this evidence to show a pattern of behavior. Court orders. These documents can support the prior difficulties claim and may reveal pertinent information from prior depositions. Spontaneous statements. These are statements usually offered voluntarily. It is critical to document the circumstances surrounding the statement relevant to time, emotions, in response to questioning, or environment to overcome a hearsay objection if the victim recants or refuses to testify. Primary aggressor. OCGA 17420.1 requires the investigating officer to attempt to identify the primary aggressor in any domestic violence investigation. If the officer has identified the primary aggressor, the report should state how the officer came to that conclusion. Officer's observations. Officers should appreciate their ability to look at elements within a domestic violence scene and to come to reasonable conclusion based on articulated observations. For example, connecting the injury to the weapon type, the demeanor of victims and aggressors, and verification of testimony by physical evidence. Historically, officers have relied heavily on the testimony of the victim as the primary evidence to establish probable cause. Often that evidence becomes difficult to rise to the level of proof beyond a doubt at trial for conviction. Arguments come down to he said, she said, or the victim may recant the statement. Absent the testimony of the victim, officers can support a case on other forms of direct and circumstantial evidence. Investigating from the statements made at the scene, officers should look to every form of evidence that would either support or refute each claim by the parties. The first objective is to identify all relevant evidence. Second is to collect and process the evidence to its fullest potential. For example, statements should be paraphrased in the narrative with direct quotes, if possible. However, it is ideal that officers have written or recorded statements. Descriptions of physical injury are good, but a picture of the injury accompanied by a medical report is also ideal. Officers should make every effort to collect all evidence because it becomes fragile and lost with time. Law enforcement faces many challenges when responding to domestic violence. One such obstacle is the complete documentation of the incident to meet the needs of all concerned parties. A well-documented account of the responding officer's on-scene investigation is the first critical step in a successful family violence prosecution. Victims often recant testimony or fail to be available for cross-examination at trial. Documentation in the officer's report may often be the only admissible evidence at trial.